On a gray Tuesday morning in late January, when the frost still clung to the fence posts and the gravel driveway crackled under every step, Ethan Calloway opened his mailbox and found something he had never expected: a legal summons. It was not a jury notice. It was not a bill from a utility company running late. It was a formal complaint filed by the Silver Pines Homeowners Association, naming Ethan Calloway as the defendant in a civil enforcement action, and it listed violations so specific, so thorough, and so aggressively documented that for a moment he simply stood there in the cold, turning the pages slowly, rereading the same sentences as if repetition would make them make sense. The complaint alleged that his property, the same property his father had worked for 30 years, the same land that bore the original survey stakes his grandfather had watched a county surveyor drive into the earth decades before most of the people in Silver Pines were even born, was in violation of HOA regulations covering SURID of fence construction, accessory structure appearance, roof color compliance, and unauthorized commercial vehicle parking. Every allegation was precise. Every citation referenced a specific article from the Silver Pines governing documents. And every page was signed at the bottom by the same name: Rebecca Sterling, President, Silver Pines Homeowners Association. Ethan read the summons a second time at his kitchen table, with a cup of coffee going cold beside him. He had never attended a Silver Pines meeting. He had never received their newsletter, never sat through one of their budget presentations, never participated in a vote on landscaping standards or entrance gate upgrades. He had never paid a single dollar in dues. He had never signed a declaration of covenants, conditions, and restrictions. He had never, in any form whatsoever, agreed to be governed by any homeowners association because, as far as he had always understood, and as far as every document in his family's possession confirmed, his property existed entirely outside the Silver Pines development. His land was older than the subdivision. His land had boundary markers that predated the developer's filing by decades. His land, in short, had nothing to do with Silver Pines or anyone in it. And yet, here was a 12-page legal complaint telling him otherwise, backed by the full enforcement authority of an organization he had never joined, demanding compliance with rules he had never agreed to follow, and attaching a schedule of fines that had apparently been accumulating in his absence for months. The longer he sat with it, the less it felt like a misunderstanding. It felt like something far more deliberate. What made it stranger still was the certainty behind it. The complaint did not read like the work of someone who thought they might have an argument. It did not hedge or qualify or leave room for alternative interpretations. It read like the work of someone who had already decided they had won, who was merely completing the procedural steps on the way to a conclusion already reached. Every paragraph was confident. Every citation was footnoted. There were even photographs attached, images of his barn, his storage shed, his fence line, his truck parked in his own driveway on his own land, presented as evidence of ongoing violations, as though the existence of a working farm constituted an offense requiring correction. Someone had been watching his property closely enough to build a photographic case file. Someone had walked near his boundary with a camera and spent time framing shots and printing them on HOA letterhead. Someone had been waiting for this moment for a while. And when Ethan reached the final page and saw that the filing had been submitted just 11 days earlier, he realized that whoever had set this in motion had done so quickly, efficiently, and with the kind of organizational precision that suggested they had been planning it long before the first letter arrived in his mailbox. He set the summons on the table, finished his coffee, and said nothing to no one, because he lived alone and the house was quiet. But something had shifted in him, a slow, methodical kind of anger that did not flare and did not cool, the kind that simply begins to work. He thought, Rebecca Sterling does not know whose land she is filing against, but she is about to find out. Rebecca Sterling had lived in Silver Pines for 11 years, and for 9 of those 11 years, she had served on the Homeowners Association board, first as secretary, then as vice president, and for the past 4 years as president, a position she had won not once but twice, with increasing margins each election cycle. She was 47 years old, trim and deliberate in her appearance, and she operated with the kind of measured composure that made people uncomfortable in ways they could not immediately name. She did not raise her voice at community meetings. She did not send angry texts in the neighborhood group chat. She did not post inflammatory things in online neighborhood forums. She sent formal letters on HOA letterhead, made motions through proper procedural channels, and referenced specific articles from the Silver Pines governing documents with a fluency that most attorneys would admire. She knew the rules by heart, every restriction, every standard, every footnote, and she deployed them with the calm precision of someone who understood that bureaucratic authority exercised quietly is often more effective than confrontation. To anyone who observed her from a distance, she looked like exactly what she claimed to be: a dedicated community steward committed to maintaining property values and quality of life for every resident in Silver Pines. But the residents who had lived there long enough told a different story. Not a story of cruelty. Exactly, Rebecca Sterling was never cruel in any obvious way. It was subtler than that, and in some ways more difficult to argue with because of its subtlety. There was the time she sent a certified letter to the Harmon family requiring them to repaint their front door within 30 days because the shade of red they had chosen deviated from the approved palette by a measurable degree, not dramatically, not visibly to any reasonable eye, but measurably, and that was sufficient. There was the time she fined the Patterson family for parking a boat trailer in their driveway on a Saturday, even though the trailer was gone by Sunday evening and they used it twice a year. There was the ongoing enforcement campaign against raised garden beds in front yards, against wind chimes that she classified as noise nuisances under a provision that had never previously been enforced, against basketball hoops left at the curb after 7 in the evening. Each action was technically within the scope of the Silver Pines governing documents. Each fine was formally issued and procedurally correct, but the cumulative effect, the constant surveillance, the escalating documentation, the sense that any misstep would be noticed and recorded and responded to with official correspondence, had turned Silver Pines into a place where residents moved carefully, where neighbors stopped making casual changes to their own homes without consulting the regulations first, where the homeowners association had become less a community organization and more a monitoring apparatus that ran on Rebecca Sterling's personal sense of order. Longtime residents had noticed something else as well. For several years, in various board meetings and in conversations at the entrance gate, and in the parking lot after community events, Rebecca had mentioned the Callaway property in a particular tone, not hostile, exactly, but pointed in the way that a finger is pointed at something that needs to be dealt with. She referred to it as an anomaly. She described it as a situation that would need to be addressed eventually, that the board should be aware of, that represented a kind of unfinished business at the edge of the community. When neighbors asked what she meant specifically, she was never specific, but the implication was always the same. The old farm on the edge of the development, with its weathered barn and its diesel truck and its fence posts that did not match Silver Pines' aesthetic standards, was a problem, a visual inconsistency, a reminder that not everything within sight of the community was under the community's control. And Rebecca Sterling did not like things that were not under control. No one who heard her say these things thought she was bluffing. She had never bluffed about anything in her professional life. She had simply decided somewhere along the way that Ethan Callaway's property was hers to govern, and she had moved accordingly, the way she always moved, deliberately, procedurally, and without the slightest acknowledgement that she might be wrong. The letters began arriving in early November, about 3 months before the lawsuit. The first one was relatively mild, a notice that Silver Pines had identified potential violations on properties adjacent to the development boundary and was conducting a formal compliance review. The language was impersonal and nonspecific, the kind of language designed to communicate authority without inviting a response. Ethan read it, set it aside, and thought nothing more of it for reasons that seemed obvious to him. He was not a Silver Pines resident, their compliance review had nothing to do with him, and the notice would presumably resolve itself once someone checked a map. The second letter, which arrived 2 weeks later, was considerably less mild. It referenced specific structures on his property, his storage shed, his post and rail fence along the south boundary, his barn visible from the entrance road, and cited them against Silver Pines construction and appearance standards with article numbers and subsection references. It demanded a written response within 15 days and noted that failure to respond would be considered an acknowledgement of the violations. Ethan did not respond because he did not believe he was required to. He was not a member of Silver Pines. Their standards did not apply to him. He had no obligation to engage with their process. The third letter was accompanied by photographs, 12 of them, printed in color on HOA letterhead, each annotated with arrows and captions identifying what Silver Pines considered to be specific violations. The storage shed was too tall according to the accessory structure height limits. The fence boards were the wrong color according to the exterior materials standards. The barn roof was a shade that fell outside the approved range for outbuilding finishes. The truck, a 10-year-old diesel pickup that Ethan used for hauling feed and farm equipment, had been photographed parked beside the barn and classified as a commercial vehicle in violation of residential parking regulations. Ethan stood at his kitchen counter and looked at the photographs for a long time. Someone had been standing near the boundary of his property with a camera on multiple occasions. Someone had taken 12 photographs of his home, his outbuildings, his working equipment, and organized them into a numbered legal exhibit with captions. It was thorough, it was intrusive, and it communicated something that unsettled him more than the content of the letters themselves. This was not casual, and whoever was doing it was not going to be dissuaded by silence. Then the fines started arriving. The fourth letter assessed a fine of $250 for each active violation, compounding weekly until remedied. The fifth letter added new violations: his gate latch hardware, the visibility of a tarp over a piece of equipment, the height of the grass along his south fence line. The sixth letter, which arrived just before Christmas, noted that if Ethan failed to appear at a scheduled compliance hearing on the date specified, the HOA reserved the right to pursue all available legal remedies, including injunctive relief. And then, in early January, a man Ethan did not recognize pulled into his driveway in a white pickup truck, climbed out holding a clipboard and a folded map, and introduced himself as a contractor working on behalf of a property management company. He said he had been contacted about conducting a utility easement survey along the south boundary of the adjacent residential development. He had paperwork. He wanted to confirm access. He asked if Ethan had already been contacted about authorizing the survey. Ethan told him he had not. He told him to leave. The contractor left without argument, looking mildly confused and somewhat apologetic, as though he had stumbled into something he had not been fully briefed on. Ethan stood in the driveway long after the truck had gone, watching the road and thinking. He could not make the easement survey fit with the rest of it, but he filed it away, because something in him said it mattered. It was the contractor's visit that finally moved Ethan from passive resistance into active investigation. Until that morning, he had been treating the letters and the fines as a nuisance, an elaborate, bureaucratic nuisance, but a nuisance nonetheless, the kind of thing that would eventually collapse under its own absurdity once someone with authority looked at it properly. But easements were different. Easements were legal instruments, recorded in public records, with specific legal meanings and specific legal consequences. If someone was attempting to establish or exercise an easement on his property, particularly along the south boundary, which was the side facing Silver Pines, that was not a compliance matter. That was a property rights matter, and it required documentation and a clear understanding of the legal record, not patience. On a cold Wednesday morning, Ethan drove to the county recorder's office, requested access to the property files for his parcel, and sat down at a long table with a stack of folders that turned out to be considerably thicker than he had expected. His family had owned the land for 53 years. The original purchase had been made by his grandfather, who had bought 214 acres from a retiring cattle farmer in the early 1970s, and the deed was written in the careful, formal language of that era: metes and bounds, descriptions, compass bearings, reference to physical landmarks and named watercourses. Ethan had seen the deed before but had never studied it with the attention he brought to it now, running his finger along every line, cross-referencing it against the plat map he had also requested, tracing the boundaries of his parcel against the recorded boundaries of the surrounding property. What he found in that first session was not a final answer, but it was the beginning of one. When Silver Pines had been developed, beginning in the late 1990s, the original plat map had shown a development footprint that was noticeably smaller than its current boundaries. The subdivision had grown in phases, adding sections as new parcels were annexed and platted over the following years. At each phase, the developer had filed updated plat maps with the county recorder. Ethan laid the maps side by side, the original 1997 filing and the most recent version from 2008, and compared them carefully against his own parcel boundaries. His property was not on either map as part of Silver Pines, but the Silver Pines boundary line on the most recent map ran measurably closer to his fence line than the boundary on the original map. It was not a dramatic difference on paper. It was a matter of yards in most places, feet in others, but it was real, and it was recorded, and it suggested that somewhere in the history of Silver Pines' expansion, the boundary had moved or had been drawn as though it had moved, which was not the same thing as it actually having moved. Near the bottom of the stack, Ethan found a notation he did not immediately understand. It was a cross-reference to a survey record from 1982, filed not by any private party but by the county itself, as part of a regional land use and boundary assessment. The notation included a map reference number and a field marker identifier, a code that corresponded to a physical boundary monument placed in the field during that survey. Ethan wrote the code down carefully. He did not know what it meant yet in full legal terms, but he knew it was old, official, and tied to a physical object that still existed somewhere on or near his land. He drove home that evening with a folder full of certified copies and a question that had not existed that morning. Where exactly was marker R-14, and what did it legally establish? The next morning, Ethan put on his work boots, unfolded the 1982 survey map he had printed from the digital archive, and walked his south fence line from end to end. The map was hand-drafted and slightly faded in its digital reproduction, but the field notations were legible, and the reference point for the boundary marker was described relative to a creek bend and a specific property corner that Ethan recognized from his own experience of the land. He had walked that corner 100 times without ever attaching official significance to it. He moved through the lower pasture where the grass was still winter gray and the ground was soft and yielding under his boots after a week of rain. He found it in a shallow depression near the tree line, tucked between two young oaks that had clearly grown up around it over the decades. A stone post, roughly 18 inches of it above ground, perhaps 8 inches square, set deep and solidly into the earth. It was covered along two of its faces with lichen, the color of aged copper, and the stone itself was a darker gray than the surrounding soil, the kind of stone that has been in one place for so long that it becomes part of the landscape rather than a feature placed upon it. Ethan crouched beside it and brushed the lichen back carefully from the northeast face. The chiseling was still clean beneath the growth-precise marks made by someone who knew the work would need to last. There was a reference number that matched exactly the notation in the county records. Below it, a date, 1982. He took photographs from 6 different angles, took a GPS reading of the precise location using his phone, and noted the coordinates in his notebook. Then he stood up and looked northeast across the winter field, toward the roof lines of silver pines visible over the tree line about 300 yards distant. The stone was silent and utterly indifferent to the drama being conducted in its name. It had been in this pasture for more than 40 years, through every weather and every season, through the entire lifespan of Silver Pines and through all of Rebecca Sterling's tenure as its president. It had never been moved. It had never, as far as he could determine, been referenced in any Silver Pines document. And if it meant what he believed it meant, if it marked the legal boundary established by the county's own survey, then his entire property, every outbuilding and fence line and parked truck, lay clearly and permanently outside Silver Pines' legal boundary, and had for every one of the 53 years his family had owned it. He drove back to the county recorder's office that afternoon. The archivist working the counter was somewhere in her 60s, with reading glasses on a chain and the calm, unhurried efficiency of someone who had spent decades organizing the paperwork of other people's land disputes and had seen most things there were to see. Ethan laid out his photographs, the survey notation, and the plat map comparisons, and asked if she could help him understand the legal standing of a 1982 county survey monument in relation to a subsequent developer's plat maps. She looked at the photographs. She looked at the notation. She compared the plat maps. She was quiet for a moment. Then she looked at Ethan over the top of her glasses with an expression that was not quite surprise but was something adjacent to it, and she said, "If this document is still in effect, and the monument is where you're saying it is, then somebody is in very serious trouble." She said it quietly, almost to herself, the way a person states a fact that requires no embellishment. She did not elaborate. She returned to her work. Ethan drove home. The following 2 weeks were the most productive of the entire episode. Ethan built his case with the methodical patience of someone who understood that what he was assembling would need to hold up under adversarial scrutiny in a formal legal proceeding. He returned to the archives 3 more times. He submitted a formal records request to the county planning department for the original Silver Pines development approval documents, which required a week's processing time. He obtained certified copies of his family's complete chain of title, going back to his grandfather's original purchase. He contacted the successor firm of the engineering company that had conducted the 1982 county survey and confirmed that records from that era were still maintained and that the boundary monuments placed during that assessment remained on the official record. He kept everything in labeled folders, organized first by date and then by category, and he made duplicate sets of the most critical documents because he did not intend to hand over his only copies to anyone. Deep in the planning department files in a folder that appeared to have been undisturbed for many years, judging by the yellowing of the pages and the rust that had formed where the staples touched the paper, he found what he had not known he was looking for until he found it. It was a legal memorandum, 2.5 pages long, written in 1998 by a county attorney and addressed directly to the Silver Pines developer, with a copy to the county planning board. The document carried the formal header of the county legal office and the date of its execution in the upper right corner, and it had been filed behind a tab labeled Boundary Compliance Advisory, the kind of label that sounds important to the person who created it and means nothing to anyone who has not been specifically told to look for it. The memo was written in plain, careful legal language without rhetorical flourish, the kind of document that was written to be understood and referred to rather than argued over. Its central point was stated in the second paragraph and repeated in the conclusion. The Silver Pines development, as proposed and as approved, was bounded on its eastern and southern borders by the survey monuments established during the 1982 county assessment. No extension of HOA jurisdiction beyond those boundaries could be legally executed without written, recorded consent from each affected adjacent landowner. The developer was explicitly instructed that any assertion of HOA authority over parcels outside the monument-defined boundary would be legally unenforceable, regardless of proximity or visual relationship to the development. The memo had been signed by the county attorney, stamped received by the planning department, and filed as part of the official development record. It had been there for 25 years. It was a public document. Anyone who had done what Ethan had just done, submitted a records request, and spent a few hours in the archives, could have found it at any time. Ethan read the memo 3 times at the planning department table, each reading slower than the last, letting the specific language settle into his understanding. He read the paragraph about written recorded consent twice by itself. He read the sentence about legal unenforceability twice. Then he sat back in the chair and thought about nothing in particular for a full minute, the way a person sits when they have just found something they were not certain would be there. Then he had the document certified and copied 2 sets of copies, one for his files and one to keep separate in case something happened to the first. On the drive home, he thought about everything that had happened since that first letter arrived in November. He thought about the fine notices with their compounding amounts. He thought about the photographs of his barn and his truck. He thought about the contractor who had appeared in his driveway with easement survey paperwork. He thought about the months of pressure, methodical, organized, relentless pressure that had been applied to a man who had committed no violation and broken no rule, because he had never been subject to any rule in the first place. Rebecca Sterling had built an enforcement campaign, filed a lawsuit, and attempted to impose her authority over another person's private property based not on legal documentation but on an assumption that no one at Silver Pines had ever tested against the actual record, because no one had apparently considered that the record might say something different. The memo had been in the files the entire time. The stone had been in the field the entire time. Neither had changed, and neither had moved, and neither had ever suggested anything other than what they clearly, plainly said. 1 week before the court date, the attorney representing Silver Pines sent a letter proposing mediation. The language was careful and professionally non-committal. It did not acknowledge any legal deficiency in Silver Pines' position, and it did not withdraw any element of the original complaint. It simply suggested that both parties might benefit from a facilitated informal resolution before the matter proceeded further. Ethan read the letter standing at his kitchen counter on a Thursday evening, and he recognized it immediately for what it was. He had dealt with enough business negotiations over the years to understand that parties who believe they are winning do not offer to settle. They proceed. Mediation proposals from plaintiffs are not acts of goodwill. They are signals of concern, dispatched when someone on the other side has reviewed the evidence and concluded that the ground is less solid than it looked. He thought about the 1998 memo. He thought about the certified chain of title. He thought about the GPS coordinates of a granite marker that had been in the county records for 42 years. He thought about what Silver Pines' attorney had presumably seen when he reviewed the documentation. He declined the mediation offer in a brief, polite letter that gave no reasons, because he did not owe anyone reasons. 2 days after that, through a source he had no intention of naming, Ethan received a copy of Silver Pines' board meeting minutes from approximately 3 years earlier. The minutes covered routine business for most of their 4 pages: budget items, vendor contracts, committee updates, entrance gate maintenance. But on page 3, There was a section titled Boundary and Jurisdiction Discussion, and in that section the minutes recorded that Rebecca Sterling had proposed that the board explore the legal feasibility of extending HOA jurisdiction to include certain adjacent parcels, specifically citing their aesthetic impact on the visual character of the community. The proposal had been discussed but not formally voted on. No attorney had been consulted. No outreach had been made to the property owners who would be affected. The item had been tabled for future consideration, which was recorded in the minutes with no follow-up action noted, but the meaning of the entry was unmistakable. 3 years before filing a lawsuit, Rebecca Sterling had been actively working on a strategy to bring Ethan's land and possibly other adjacent properties into Silver Pine's governance structure. Not because she had a legal basis for doing so, because she had decided it would be preferable. The lawsuit was not an enforcement action against an existing member. It was an attempt to establish jurisdiction that had never existed, dressed in the procedural language of compliance enforcement, conducted against a man who had never agreed to be governed. Ethan added the board minutes to his folder, made a duplicate copy, and went to bed. The morning of the hearing was clear and cold. The sky, that particular shade of pale winter blue that comes after a week of overcast weather, when the light is sharp and everything at a distance looks slightly more precise than usual. Ethan arrived at the courthouse 20 minutes early, carrying his folders in a canvas bag, and sat on a bench in the hallway reading through his documents one final time, not because he had forgotten anything, but because the act of reviewing organized material has a settling effect when one is about to do something consequential. He had not hired an attorney. That was a deliberate choice made after careful consideration. He had spent weeks in the records. He had consulted with a retired land surveyor who had confirmed his reading of the boundary documentation. He understood the relevant statutes. He believed his materials were sufficient to speak for themselves, and he believed that a judge reviewing them would reach the same conclusions he had. It was a calculated risk, but it was a calculation he had made honestly and with full awareness of what he was risking. Rebecca Sterling arrived with her HOA attorney 15 minutes before the scheduled hearing. She was dressed in a charcoal blazer with a silver pin on the lapel, her reading glasses on their chain, her expression composed and forward-looking in the way of someone who has prepared thoroughly and expects to perform well. She acknowledged Ethan with a brief, professional nod, not unfriendly, not warm, the neutral acknowledgement of an adversary she did not consider particularly formidable. Her attorney, a man in his mid-50s who handled HOA enforcement work regularly and carried the relaxed confidence of someone for whom these hearings were routine, shook Ethan's hand, made a brief comment about the weather, and took his seat at the plaintiff's table. Rebecca sat beside him, set her own folder on the table, and looked toward the front of the courtroom. She had the settled quality of someone whose outcome she considered already arranged. The morning's proceedings, in her mental model, were a formality. Judge Harriet Olson had been presiding over civil matters in this county for 16 years. She was efficient and precise, with the kind of attention that good judges develop over long careers, the ability to follow what is being said while simultaneously tracking what the documentation actually shows, noting the gaps between the two. She reviewed the filings, confirmed the parties and the nature of the action, and asked the HOA's attorney to present the basis for the complaint. He did so with practiced fluency. The property was adjacent to the development. It had been identified as subject to community standards. The defendant had failed to respond to repeated formal notices, and the association was seeking compliance and recovery of assessed fines. He cited the governing documents. He referenced the plat map on which the HOA's claim rested. He introduced the photographs. It was a clean, professional presentation that assumed the jurisdictional question was settled and that the only matter before the court was the defendant's non-compliance. When Ethan's turn came, he did not open with an argument. He placed 5 documents before the judge and the opposing counsel in certified copies, presenting each one briefly and letting it stand on its own. The 1982 county survey record, with the boundary monument identifier, the certified chain of title to his property, showing continuous family ownership for 53 years. The comparative plat maps, showing the discrepancy between Silver Pine's recorded boundary and the county survey monuments. The GPS-verified location of marker R-14, with photographs showing the monument as it currently existed in his lower pasture, and the 1998 legal memorandum from the county attorney, addressed to the Silver Pines developer, stating with explicit clarity that HOA jurisdiction could not extend beyond the monument-defined boundary without recorded written consent from adjacent landowners, consent that had never been obtained. He set the last document before the judge and sat down. Judge Olson read the memorandum. She read it completely and without visible reaction, the way people read things that require their full attention. The courtroom was quiet for the duration. When she finished, she set it down, looked at the HOA's attorney, and asked whether Silver Pines had, at any time since the development's founding, obtained written, recorded consent from adjacent landowners to extend HOA jurisdiction beyond the boundaries established by the county's 1982 survey monuments. The attorney conferred in a low voice with Rebecca for a moment. Then he stood and said that he did not have documentation of such consent in the materials before him, but he would need to review the association's complete records to answer definitively. The judge said she would wait. Several minutes passed while the attorney went through his briefcase. Rebecca sat without moving, her hands folded on the table in front of her, her expression unchanged, but something in it beginning to work differently, the way a structure shifts imperceptibly before something gives. The attorney stood again and confirmed that no such consent documentation was present in his materials. Judge Olson made a note on her pad. She asked whether Silver Pines had commissioned an independent survey of its legal boundary before initiating the enforcement action. The attorney confirmed that the association had relied on its existing plat maps. The judge made another note. She then asked Ethan directly whether he had ever signed any agreement with Silver Pines or its predecessor developer in any form. He confirmed he had not. The judge looked at the 1998 memo once more, and then she looked at Rebecca Sterling with complete attention, without hostility, in the way a judge looks at someone when the question being asked is the most important one in the room, and she said, "Miss Sterling, on what legal basis did Silver Pines assert jurisdiction over the defendant's property?" It was not a rhetorical question. It required a specific, documentable answer, and for the first time that morning, Rebecca Sterling did not have one. What followed was not dramatic in the theatrical sense. There were no outbursts, no confessions, no sudden reversals of position. What happened was quieter and, because of its quietness, more complete. The systematic exposure of an assumption that had been used as the foundation of a legal action. Judge Olson set aside entirely the question of whether Ethan had violated any HOA rule on the grounds that this question was moot if Silver Pines lacked jurisdiction over his property. She focused the remainder of the hearing on that jurisdictional question, and in that reframing, the entire character of the proceedings changed. Silver Pines was no longer the plaintiff asserting its authority. It was an organization being asked to demonstrate a legal basis for authority it had been exercising without verification. The attorney made several attempts to reconstruct a workable argument. He pointed to the proximity of the parcels. He referenced community character and shared visual environment. He suggested that the discrepancy between the plat maps and the survey monuments might be a technical drafting issue rather than a substantive boundary question. Judge Olson addressed each argument steadily and without impatience. Proximity was not jurisdiction. Visual preference was not legal authority. A documented county attorney's memorandum was not a drafting issue. Rebecca was questioned directly and at length about the history of the enforcement campaign. The judge asked specific questions and waited for specific answers, moving through the timeline from the board meeting discussion 3 years earlier to the contractor visit in January, asking at each point what legal review had been conducted, what authority had been verified, what documentation had been consulted before the next step was taken. Rebecca answered clearly and without visible distress, which spoke to either genuine composure or the particular quality of denial that well-organized people sometimes carry into situations they are not prepared for. But the answers themselves, honest as they were, assembled into a picture that grew less defensible with each exchange. She confirmed that she had raised the question of adjacent properties at the board meeting 3 years earlier. She confirmed that no legal counsel had been engaged before the enforcement letters were sent. She confirmed that the decision to file the complaint had been made on the basis of the existing plat maps and the assumption that the property was within Silver Pines' boundary. She answered honestly, which made the answers more damaging than evasion would have been, because what the honest answers revealed was the complete picture. An organization that had initiated legal action, sent months of threatening correspondence, assessed compounding fines, and brought a private citizen into court, all built on a foundation that no one had bothered to check against the official record. The legal memorandum had been in the county files for 25 years. The boundary monument had been in Ethan's lower pasture for 42. Neither had ever moved. Neither had ever been hidden. They simply waited, in the patient way that documented facts wait, for someone to come looking. The judge kept the file for formal review and indicated a written ruling would follow within 3 weeks. As people gathered their materials and the bailiff moved toward the courtroom doors, Ethan looked across the room at Rebecca Sterling. She was at the plaintiff's table speaking quietly with her attorney, her back partially turned. She was still composed, that part of her had not changed. But the particular quality of certainty that she had carried into the room, the sense that the day's proceedings were a formality on the way to a conclusion already written, was gone. In its place was something more effortful, the kind of composure that is maintained by will rather than by confidence. She looked like a person who had just discovered, in a public setting, that the map she had been navigating by did not match the territory. Ethan picked up his canvas bag, nodded briefly to no one in particular, and walked out into the pale February light. The ruling arrived 3 weeks later, delivered by regular mail in a plain envelope from the county civil court clerk, and it was 11 pages long. Ethan sat down at his kitchen table with it and read it from the first paragraph to the last, the same table where he had sat with the original summons in January, the coffee going cold beside him in the same way it had then, but the feeling in the room entirely different. Judge Olson's conclusions were stated without qualification. Silver Pines Homeowners Association did not have legal jurisdiction over the Callaway property. The enforcement action was dismissed in its entirety. All assessed fines were declared void and unenforceable. The court further noted that the Silver Pines plat maps filed after 2003 contained boundary representations inconsistent with the county-established survey monuments, and that these inaccurate maps had been used as the operative basis for enforcement actions that had no legal standing. The opinion recommended that the county assessor's office conduct a formal review of the Silver Pines boundary filings and take corrective action as appropriate. It was a complete ruling. It left nothing partially resolved. The consequences extended well beyond Ethan's property line and beyond anything the original lawsuit had contemplated. The ruling, once it became a matter of public record, was not something that could be quietly filed away. Several Silver Pines residents who had received enforcement notices over the years, particularly those in sections closest to the development's edges, began requesting copies of the ruling and consulting with attorneys about their own situations. Questions that had never been asked publicly were being asked at board meetings. A formal motion was introduced, requiring an independent legal audit of all enforcement actions against non-member or boundary-adjacent properties over the previous 5 years. The county assessor's review was opened and was expected to take several months, and within the board itself, the consensus that had surrounded Rebecca Sterling for years began to fracture visibly. Members who had seconded her motions without comment began asking for documentation. Votes that had previously been unanimous began showing dissent. At the board meeting 6 weeks after the ruling, Rebecca Sterling announced that she would not seek a third presidential term. She did not provide a reason. No one asked for one. Ethan heard about the announcement from a neighbor who lived near the development entrance. He received the news with the same quiet attention he had brought to everything else about the situation, not with satisfaction, not with any particular feeling about Rebecca Sterling personally, but with the recognition that what had ended was something that should never have begun. He had not set out to expose anyone, or to become a cautionary example, or to be the person who brought down a homeowners association president. He had not filed a counterclaim, or sought damages, or spoken to the local newspaper, or made any public statement about the matter. He had gone to the county archives because a lawsuit had been filed against him, and he had looked at the records because the records existed, and he had brought what he found to court because that was what the situation required. It was not more complicated than that. On the Saturday after the written ruling arrived, Ethan spent the morning doing ordinary farm work, feeding the horses, checking the south fence line for winter damage, replacing a board on the storage shed gate that had warped from the freeze-thaw cycles of the past 2 months. It was good work, the kind that required physical presence and produced visible results, and it felt appropriate to the day. In the afternoon, he drove out to the lower pasture, when the light was coming in low and gold from the western tree line, and the shadows of the fence posts stretched long across the new green grass of early spring. He parked near the creek bend and walked across the pasture to the stone marker. It looked precisely as it had always looked, old and set, and completely indifferent to everything that had been said and argued and decided in its name over the preceding months. The lichen had grown back slightly over the chiseled numbers. The 2 oak trees that flanked it had begun to bud. The GPS coordinates he had recorded on that first morning were still accurate to within a meter. Nothing had changed, because the things that matter in these situations do not change. His grandfather had watched this marker placed. His father had walked past it on this same ground without knowing what it meant in legal terms, only that the land was his and the boundary was where it was. Ethan stood beside it for a while, without any particular agenda, just present in the afternoon light on the land that had always been his, and that would remain his after everything that had happened was fully forgotten. There is a particular kind of confidence that resembles authority without being authority. It presents itself without hesitation. It produces documentation and cites regulations and speaks in the language of rules and standards and community obligations. It operates through institutional channels and uses official stationery and refers constantly to governing documents and proper procedures. And because it does all of these things, because it is organized and persistent and never expresses doubt, it is often mistaken, including by the person exercising it, for something more substantial than it actually is. Rebecca Sterling had built a professional identity on this kind of confidence. For years it had been sufficient. In the absence of anyone who pushed back, in the absence of anyone who went looking for the actual legal record, the confidence itself had served as authorization. She had governed her community with it, and she had extended it toward Ethan's land without anyone stopping to ask whether the extension was warranted. No one had checked the archives. No one had walked the fence line looking for the physical markers the county had placed and recorded. No one had submitted a records request and spent an afternoon in a room full of old folders. No one had looked for a stone post in the lower pasture because no one had imagined that a stone post was the kind of thing that could undermine years of confident administration. That was, in the end, the central failure, not malice, and not even ambition exactly, but the failure to imagine that the records might say something different from what the assumption had always insisted. Ethan Callaway was not a complicated man in the way that phrase is sometimes meant as an insult. He was patient, he was methodical, and he was attached to the land in the way that people become attached to things they have inherited from people they loved. He had not wanted a legal fight. He had not wanted to spend months in the county archives and in courtrooms and in conversations with archivists about survey monuments. He had wanted to live on his property the way his family had always lived on it, without interference from people who had decided that his choices fell within their jurisdiction. When a lawsuit arrived in his mailbox claiming otherwise, he did the thing that was available to him. He looked at the record. He followed the paper trail from its beginning, through all its decades and filing numbers and map revisions, to the thing it pointed to: a stone in a field, chiseled with a number and a date, placed there by the county, and recorded officially, and never moved and never hidden, and never anything other than what it was. The law, in this matter, was not interested in what Rebecca Sterling believed. It was not interested in her vision for what Silver Pines should be, or in how many years she had invested in maintaining it, or in how confident she had appeared on the morning the hearing began. The law was interested in the 1982 survey record. It was interested in the 1998 memorandum. It was interested in the GPS coordinates of a boundary monument sitting in a pasture in early spring, indifferent to everything, marking with absolute precision the place where what someone imagined ended and what had always been legally true began. That place had been there before the dispute. It would be there after the last person involved had forgotten it. Ethan Callaway walked back across the pasture to his truck, drove home along the county road as the afternoon light faded from gold to gray, fed his horses, and let the evening settle over the land in the quiet way that evenings settle when there is nothing left to prove.